Frustrated with tighter fishing restrictions on Lake Mille Lacs, resorters and sport fishing groups had their day in court.
They're suing the Department of Natural Resources, claiming it ignored a constitutional amendment. In 1998, Minnesota voters passed the amendment to preserve the state's hunting and fishing heritage. When the DNR passed emergency fishing rules last spring, the groups contend they had no say in that. Bill Hudson was in court today.
Mille Lacs Lake is among the state's premier walleye fisheries, but fewer fish and stricter limits have sent many anglers elsewhere.
They have put this lake out of balance.
Resorters like Bill Eno and other anglers cite mismanagement by the DNR. So today, their lawsuit against the agency landed in the State Court of Appeals.
This whole area of Mille Lacs has been devastated. The community, the way of life, the human environment is a shadow of what it once was.
Attorney Eric Cardall argues the DNR has ignored constitutional guarantees of the state's Outdoor Heritage Amendment after imposing a night fishing ban and tighter limits without public input. Judge Natalie Hudson, though, took issue.
Seems to me they proceeded according to their statutory authority to preserve and protect the walleye.
But the state's attorney, Oliver Larson, argues the Heritage Amendment was aimed at the legislature to prevent attacks on our hunting and fishing culture and not the management of it.
These are, biologically necessary restrictions on the fishing to ensure that the population doesn't collapse.
The DNR contends the tight regulations are completely in line with the amendment's intent.
If we were not managing the lake to bring that walleye population back, there would be no heritage.
The three-judge panel now has 90 days to issue a ruling. A ruling could force the DNR to show why it did not consider the Heritage Amendment. However, any ruling will come about the same time that the new fishing rules are being considered for the 2015 season.